Hello, with us today is the Honorable Michael Kaplan, Chief Bankruptcy Judge in New Jersey. Judge Kaplan began practicing, or began on the bench in New Jersey in 2006. And during that time, he has handled many complex cases of all types and sizes. And from that experience has sensed a need to utilize a case management tool in complex cases that is commonly used by district courts. But unfortunately, the bankruptcy rules prohibit the use, and that is the special master. And the prohibition comes from Bankruptcy Rule 9031. So Judge Kaplan has embarked upon an effort to change that rule to allow the use of that tool. So welcome, Judge.
Thank you, Don. It's great to be here.
Thank you. And let's just jump right in. Could you tell us what special masters do in non-bankruptcy cases?
Sure. Well, let's give a little background. So the use of special masters can be traced back to the civil rules of procedure that were implemented in about 1938. And it allowed the district courts to use adjuncts for trial matters. They were essentially trial masters that assisted in fact-finding, in reviewing and hearing testimony, and making limited factual findings, which would be reviewed on a clearly erroneous standard by the appointing judge. Over the years, though, from 38 on, district courts began using their inherent authority to expand the scope of the work special masters would be doing. They would not just be focused on trial work. They would be primarily pretrial discovery disputes, assisting in settlement negotiations, assisting in the implementation of judgment and post-judgment disputes, and also administering settlement funds on a wide variety of types of litigation. Back in 2003, both Congress and the courts recognized that the role of a special master had certainly blossomed, and they codified some of the changes. Now, previously, special masters were only to be used in extraordinary circumstances, or if the parties had consented, or in complex matters warranting a special expertise. The changes in 2003 recognized that special masters should be used on an as-needed basis if the parties consent, or exceptional situations where the court would enter an order requiring it. But it also codified certain procedures for appointing the special master. It authorized the special master to provide services both pre-petition, during discovery, and as well as trial and post-trial matters. The new rules set up a new standard of review. The work of special masters was going to be reviewed not on a clearly erroneous standard, which is pretty high, but on a de novo standard by the appointing judge. The changes also applied certain judicial ethics requirements and conduct mandates. The parties had a right to have input in the selection of a judge's appointment of a special master, and also have the right to object to the special master's report on the factual findings. Procedural matters were still subject to a clearly erroneous standard. And that's where we stood and stand today, that there's significant use by the district courts, both district court judges and magistrate judges, to employ special masters for discrete areas where they can assist the tribunal and the judges move cases efficiently and economically.
So why then have the special masters been excluded from bankruptcy cases?
Good question. I'm not sure there is a true answer to that. Again, we go back to history. Before the current bankruptcy code, when we were working under the Bankruptcy Act of 1898, and the bankruptcy rules that were in play at that time, special masters were permitted to be used by the district courts, because remember, the district courts had the authority over the bankruptcy cases, and while they used bankruptcy referees to assist in certain areas, it was still the subject matter rested with the district courts. With the code changes that were implemented in 1979, we saw a change, and for some reason, the bankruptcy rules no longer permitted the use of a special master for now bankruptcy judges. There's no commentary explaining the basis for rule changes, not in legislation. It may have been a reaction to the changes in the code in 1982 with the Supreme Court's decision in Northern Pipeline, but we're not sure. About 1995, the issue came before the Administrative Office of the Courts and two committees. In fact, there was an advisory committee on bankruptcy rules, which was requested by another advisory committee, the Advisory Committee on the Administration of the Bankruptcy System, to review whether amendments to rule at the time 9031, which is our current rule, should change to allow for the use of special masters by bankruptcy judges. And it was supported at the time by the ABA to have the changes, and it was supported by the Advisory Committee on the Administration of the Bankruptcy System to make these changes. But the Rules Committee declined in a 8-5 vote, rather close vote. And at the time, the Rules Committee relied heavily on an analysis by the reporter to the committee, Professor Alan Resnick, who was troubled by the standard in play at the time, the clearly erroneous standard, and how that might undercut the authority of a bankruptcy judge. And also, he didn't see that it was necessary or efficient to have to permit the appointment of special masters, given the ability to appoint examiners and trustees. Well, we're now 27 years later, and things have changed in the practice. But more importantly, the rule changed. The underlying rule 53 changed, as I indicated, and altered the standard of review. It's no longer that clearly erroneous standard. It's simply a de novo review by the appointing judge. So that primarily addressed Professor Resnick's concern. And as far as being necessary or efficient, the role of a special master has changed over the years, and the needs have changed. We look at now a very different landscape in our Chapter 11 practices as far as complexity and issues that we're facing as judges. So there's a new push, I'm hoping consideration by the Bankruptcy Rules Committee to reconsider its decision that goes back to 1995 in light of the changed landscape.
So then why should special master appointments be allowed in bankruptcy now? I think you've already touched on this, but maybe give us a little focus on that.
Well, let me give it by example. So one case that came before me in the last two and a half years was the LTL Management LLC matter, the Johnson & Johnson Tel case. Yeah. And it actually was two separate cases. And in the first case, there was an issue regarding valuation of the liabilities of the claims. And I was certainly trying to find an efficient and cost-effective method of tackling that issue. And for that, I appointed Ken Feinberg as a Rule 706 expert. but that's not a special master. A Rule 706 expert doesn't have the same confidentiality protections and is essentially a witness subject to cross-examination at trial, and is not necessarily tackling the same task that would help the court in pretrial discovery, weighing in on privilege issues, or tackling discrete areas where the court could use the expertise of a third party. Then came the second Johnson & Johnson case, LTL Management 2, we'll call it. And at issue in that case was the validity of 60,000 talc claims, which were supportive of the debtor's efforts. Now, these claims were under siege by other talc claimants because, as we know, in these asbestos cases, under Section 524G, there's a requirement that any plan to be approved by 75% of those receiving under a trust. So there's going to be a battle over quantifying these claims. Who's entitled to vote? What claims are meritorious? And we had, as I said, under siege, 60,000 claims that were being challenged for as meritless or lacking a factual or legal foundation. These same issues, I think, occurred in other of our mass tort bankruptcies, the Boy Scouts case, and various diocese cases. How do we go about estimating claims? How do we go about analyzing, for voting purposes, the merits of 60,000 claims, for instance? And it would be a tremendous task. I never had to face it because the case was ultimately dismissed, but it struck me as the perfect opportunity to employ a special master to make factual findings if we had to go through tens of thousands of cases as to their merits and whether or not they should be allowed for voting purposes at a bare minimum. Now, in my view, the special master as a tool, as a vehicle for assisting our bankruptcy courts, goes beyond mass torts. We are seeing complex litigations in D&O litigation. We're seeing complex liability management transactions, pre-filing that are being challenged. We have very complex and sophisticated pre-filing transactions, leverage buyout transactions that are analyzed under fraudulent transfer parameters. We have environmental litigation. I know I have one case that is, we've entered the world of cryptocurrency, and there with a whole new set of issues, factual and legal. So it strikes me as certainly beneficial to our courts in special circumstances, not for the average and everyday Chapter 11, but in extraordinary circumstances, to be able to employ a third party to assist the court, especially in discovery disputes, to review ESI issues that have arisen in discovery, to analyze privilege claims, to help oversee the preparation of proofs of claim and the standards for these mass tort cases. There's a whole avenue that could be of work that could be assisted, and I think make our system more efficient, and produce more expeditious and timely results for the parties.
Wow, Judge, that is absolutely fascinating, and best of luck in your efforts. I'm guessing this will be interesting to follow, to say the least. So thank you. Appreciate it.